Hello friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. And friends, in today's video, we are going to discuss all the questions of Evidence Act, which came in the exam paper of JHARKHAND Judicial Services from the year 2008 to 2018. I hope कि ये वीडियोस आपके लिए बड़ी यूजफुल रहेंगी. So friends, if you are preparing for judicial services, this channel will be very useful for you. आपके लिए बड़ा ही beneficial रहेगा. And अगर आपको ये वीडियो अच्छी लगी हो तो जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ. And don't forget to subscribe the channel. And while subscribing, don't forget to press the bell icon so that you can get the notification of our upcoming videos. Next 61. Husband and wife are competent witnesses against each other in matrimonial cases or in one person in law या फिर in civil cases, civil as well as criminal cases. D is the answer. Next 62. Now list 1 list 2 को मैच करना है फिर से. Blood stains and blood group. इस एविडेंस के बारे में कौन से केस में बात की गई है? स्टेट ऑफ गुजरात वर्सेस छोटेलाल पटनी, ऑटोमेटिक कैमरा, बी वर्सेस अटॉर्नी जनरल, tape recorded statement, Rag versus Dodson, handwriting Yusuf Ali state of Maharashtra. So क्या बन गया? 2, 3, 1, 4. C is the answer. Next 63. Which of the following pair is not correctly matched? That a man heard or said something. It is a fact. It is correct. Map or plan is a document. Yes. Copies made from or compared with the original. It is an evidence. It is secondary evidence. Facts connected to a fact in issue in such a manner as to constitute part of same transaction. It is gesti, not rule nisi. So this is incorrect, not correctly matched. D is the answer. Next 64. Again, list 1 list 2 को match करना है. Confession caused by inducement, threat or promise. मैं उसको बोलता हूँ PIT, पीठ दिया उसको. सेक्शन 24 में लिखा हुआ है ये. तो कौन सा केस है इस पर? पैरेलल भार्गव वर्सेस स्टेट ऑफ राजस्थान. कन्फेशन टू कस्टम ऑफिसर, स्टेट ऑफ पंजाब वर्सेस बरकत राम. कन्फेशन इन द FIR गिवन बाय द एक्यूज्ड, अग्नू नागेशिया वर्सेस स्टेट. डिस्कवरी ऑफ फैक्ट परसुएंट टू स्टेटमेंट इन पुलिस कस्टडी, स्टेट ऑफ बॉम्बे वर्सेस काटिखालू ओगढ़. क्या बन गया इसका? 3214. ये रहा 3214. D is the answer. Next 65. Question is whether A was robbed. The fact that he said he has been robbed without making any complaint is not relevant, but may be relevant under section 32 157. D is the answer. And this is provided where? This is illustration K to section 8 of Evidence Act. Next 66. A is accused of receiving stolen goods while knowing them to be stolen. He offers to prove that he refused to sell them below their value. He may not prove the statement या फिर if it is relevant, otherwise an admission या फिर as it is explanatory of conduct influenced by the fact in issue. C is the answer. And this is illustration E to section 9 of Evidence Act. Next is 67. An admission by guardian ad litem against a minor is an evidence. No, it is not correct. Admission on point of law made by a pleader in court or behalf of client is admission. No. Admission by one or several defendant in a suit against defendant is evidence. No. Admission of fact made by a pleader in court on behalf of his evidence. This is correct. This is an admission. D is the answer. Next 68. Which one of the following is the true statement in relation to relevancy of character? In criminal cases, previous good character is irrelevant. No, it is relevant. Previous bad character is relevant. No. Evidence of good character is given. In civil cases, character to prove conduct impeded is irrelevant. This is also incorrect. In civil cases, character of any person affecting the amount of damages is relevant. This is correct. D is the answer. This is section 53. This is 54. This is 52. This is 55 in Evidence Act. Next 69. When the court has to form an opinion as to digital signature of any person, the opinion of which the following is relevant. सर्टिफाइंग अथॉरिटी और कंट्रोलर अपॉइंटेड अंडर द IT एक्ट या फिर इंटरनेट सर्विस प्रोवाइडर या फिर सर्टिफाइंग अथॉरिटी विच हैड इशूड डिजिटल सिग्नेचर सर्टिफिकेट. D is the answer. This is a repeat question. This is section 47A, and now this digital has been amended by the Amendment Act of 2009 as electronic signature certificate. This is a question paper of 2008, so amendment came later on. Next 70, which of the following cases Supreme Court raised doubt regarding the applicability of doctrine of equitable estoppel beyond section 115 Evidence Act? It was Madanappa vs Chandramma. B is the answer. Next 71, no revenue officer shall be compelled to say whence he got any information as to the commission of any offence against public revenue. It's section 125. A is the answer. Next 72, no confession made to a police officer shall be proved as against a person accused of any offence. The rationale of this rule is stated in Queen Empress versus Babulal. So B is the answer. Next 73, where a bill of exchange is drawn in a set of 5, how many of them need to be proved? 1 only. C is the answer. And where it is mentioned in section 39 of Evidence Act. Not as illustration, but the relevant provision is 39. Next 74, assertion is A gives B a receipt of money paid by B. Oral evidence is offered for the payment. The evidence is admissible. Reason, a receipt is not a contract or grant in respect of oral evidence is barred. So this is correct, and this is illustration E in section 91. And the receipt is not a grant or in respect of oral evidence of which oral evidence is barred. So these both are true, and correct explanation A is the answer. Next 75, assertion is section 91-92 Evidence Act should be read together. It is correct. These two sections supplements each other. Yes, it is correct. So both are correct. A is the answer. Next 76, the court shall take judicial notice of foreign judicial record, no. National flag of state not recognized by India, no. Stephen Digest of criminal, no. Rule of road on land and in sea, it is correct. D is the answer. The provision is in section 57-58 of Evidence Act. Next 77, which of the following is an example of may presume? Presumption as to electronic record or digital signature certificate or electronic message or agreement. As to electronic message, it is in section 88A. C is the answer. Presumption as to electronic agreement is provided in section 85A, and digital signature certificate is now changed to electronic signature certificate, and this is 85C. Next 78, section 58 of Evidence Act deals with formal admissions, evidentiary admissions, formal as well as evidentiary admissions, proof of facts by oral evidence. Formal admissions, A is the answer. Next 79, which of the following pair is not correctly matched? Relevancy of a statement as to law contained in law books, section 38 Evidence Act. It is correct. Relevancy of maps, charts, this is 36, not 35. Relevancy of certain evidence for proving subsequent proceeding the truth of fact therein stated. It is 33. Relevancy of statement as to the facts of public nature. It is 37. So two are incorrect here, B and C. Next is 80. In which of the following instances there is no reason ground for asking the witness the question whether he is dacoit? A barrister is instructed by an attorney that important witness is a dacoit. This is a reasonable ground mentioned as illustration A in section 149. Pleader informed by a person in court that important witness is a dacoit. The informant, on being questioned by the pleader, gives satisfactory reason for this statement. This is a reasonable ground. See, a witness of whom nothing whatsoever is known is asked randomly whether he is a dacoit. It is not a reasonable ground. This is illustration C. This is illustration B in section 149 Evidence Act. If a witness of whom nothing whatsoever is known, being questioned as to his mode of life and means of giving satisfactory answers. This is a reasonable ground. So what is not a reasonable ground? C is the answer. This is illustration D. Next 53. If question asked to witness to any matter relevant to the matter in issue and answer given by witness to such question will criminate him, then the witness shall be compelled to answer such question if he shall not be compelled. The witness can be compelled to answer such question. A is the answer. And where this is provided, it is provided under section 148 of Evidence Act. Next is question number 54. Estoppel has been defined under section 115. A is the answer. Next 55. The presumption of legitimacy under section 112 is a presumption of law. A is the answer. And they are talking about the Evidence Act. They should have mentioned that. Next 56. A witness may, while under examination, refresh his memory by referring to any writing made by himself at a time of the transaction or soon afterwards. This provision is provided under section 159. A is the answer. Next 57. Leading question has been defined under which section of Indian Evidence Act? Under section 141. A is the answer. Next 58. Under which section of Indian Evidence Act a public servant shall not be compelled to disclose communication made to him in official confidence? That is 124. B is the answer. Next 59. A is charged with travelling in a railway without a ticket. The burden of proving that he had a ticket is on the accused. A. B is the answer. This is section 106 and this is illustration in that section. Next 60. In respect of certified copy 30-year-old which fulfills all the conditions laid under section 90 of the Indian Evidence, the court may presume. B is the answer. Next 61. A certified copy of a registered sale deed produced in evidence will be proof of execution of the original and its registration. Yes. Okay, will be a proof of execution only, or it will be merely proof of the fact that an original document was registered. C is the answer. Next 62. Confession of one accused is admissible in evidence against co-accused if they are tried jointly for the same offence. Not differently for the same offence, but not jointly. No. Different. No. A is the answer. This is section 30 of Evidence Act. Next 63. For the purpose of proving a registered will, it shall be necessary to call at least one attesting witness. So B is the answer. Next 64. In the Evidence Act, the condition in respect of computer output to be deemed and admissible in evidence as document is contained in section 65B, but with subsection 1, 2, 4, 5. It is subsection 2. C is the answer. Next 65. Which of the following is correct in respect of determining the date of birth of A? A letter from A's deceased father to a friend announcing the birth of A is a relevant fact. This is correct. Letter from A's deceased father to a friend announcing the birth is not a relevant fact. It is wrong. Is not admissible. No. A is the answer. This is illustration L in section 32 of Evidence Act. Next 66. Which of the following is required to be proved essentially? Judicial notice have taken, so no need to. Facts admitted, no need to prove. Confession, no need to prove. Relevant fact is required to be proved. D is the answer. Next 67. Opinion of experts are not relevant. Upon a point of science, it is relevant. Art, yes. Domestic law, no. As to identify of handwriting, yes. C is the answer. It is mentioned where? Section 45 of Evidence Act. Next 68. Which of the following section provides that evidence may be given of fact in issue? It is mentioned in section 5. C is the answer. Section 6 is res gestae, 3 is interpretation, 4 is shall presume, may presume, and conclusive proof. Next 70, it has been held by the Supreme Court in R.M. Malkhani v. State of Maharashtra that a contemporaneous tape record is relevant conversation is a relevant fact. It is res gestae. B is the answer. Next 71. Section 11 of Indian Evidence Act enables a person charged with a crime to take what is commonly called the plea of alibi. And what is meaning of alibi? Elsewhere. I was somewhere else when the crime was committed. Plea of alibi, C is the answer. Next 72. A judicial admission operates as an admission. It is already an admission. Confession, no. Plea of ignorance, no. Waiver of proof. So when there is an admission, so there is no need for proof. D is the answer. Next 73. The burden of proof means the obligation to prove a fact. This is defined under Section 101 of Indian Evidence Act. B is the answer. Next 74. The principle stated in Section 106 of the Indian Evidence Act is an application of the principle of res gestae, where Section 6 res judicata in 11 CPC, rex six tantibus. This is a principle of international law. But it means TT must be followed. So what remains? Res ipsa loquitur. B is the answer. Things speaks for itself. Next 75. Leading questions can always be asked in cross-examination. C is the answer. It is mentioned where? Section 143 of Evidence Act. Next 76. Alibi is governed by... Oh, come on. Earlier they have mentioned the section and asked where is alibi. So now they are mentioning alibi here and asking the section. How easy it is to answer it. C is the answer. Section 11. 6, as I mentioned, it is res gestae. 8 about PCM. What is PCM? Preparation, conduct, and motive. Next 77. Admissions made by a party are evidence against privies in estate law blood. In estate, A is the answer. Means person having mutual interest. Next 78. Next 78. Communication made without prejudice are protected under Section 23 Evidence Act. C is the answer. Next 79. Necessity rule as to the admissibility of evidence is contained in Section 32. C is the answer. Next 80. The res inter alia acta is receivable under which section? Section 46 of Evidence Act. C is the answer. What is the meaning of res inter alia acta? Contract made by other people cannot affect the right of non-party. Next 81. Section 92 of Evidence Act applies to bilateral document or unilateral? Both. To bilateral documents. A is the answer. Next 82. Estoppel need not specifically pleaded या फिर should be specifically pleaded? It should be specifically pleaded. B is the answer. Next 83. Zahira Sheikh was prime witness in Best Bakery retrial case 2006. So A is the answer. Next 84. The presumption under Section 41 of Evidence Act is irrebuttable presumption of law because it is conclusive proof. D is the answer. Next is 100. The material fact on which a party relies are called as facta probanda. B is the answer. And on the basis of which facta probanda is proved, that is facta probentia. Next 56. Evidence Act came into force on 1st September 1872. B is the answer. Next 57. Which of the following statement is incorrect about dying declaration? Dying declaration is not defined in Evidence Act. It is correct. Under English law, expectation of death is necessary. This is also correct. Under Indian law, expectation of death is necessary. No. It must relate to the cause of death of the deceased person. They should have mentioned properly. So which is wrong in here? Which is incorrect? C is the answer. Where is the provision for dying declaration under section 32(1) of Evidence Act? Next 58. Hostile witness is defined in none of the above. D is the answer. How? It is not defined anywhere. The same question has been asked in ADA examination paper of 2016. Next 59. Match the correct option. Accomplice is mentioned in section 133. Correct. Leading question. No, it is in 141. 137 is examination in chief, cross examination and re-examination. Private document is in 75 and 74 is public document. Judicial notice in 57. So this is also wrong. And 17 is admission. So which one is correct? A, accomplice. A is the answer. Next 60. If the confession is taken in consequence of a deception, it will become irrelevant. It does not become irrelevant. It does not become irrelevant. B is the answer. Next 61. Which of the following statement is correct about evidence of character? Character includes only reputation या फिर disposition. Both are wrong now. Evidence of character is not relevant in criminal cases. This is wrong. Evidence of character is not relevant in civil cases. This is correct. D is the answer. And with the provisions for character in this option D is section 52 and all these are 53, 54 and 55. Next 62. Section 113A of Indian Evidence Act was inserted in the year 1983. A is the answer. And 113B was inserted in 1986. Next 63. Which of the following statement is incorrect about admission? It is defined in section 17. Yes. It can be made only by the party to the suit or proceedings. No. It is relevant in both civil and criminal cases. Yes. Section 23 of Indian Evidence Act applies to civil cases only. This is correct. So what is wrong? B is wrong. Next 64. Oral account of the contents of a document given by some person who has himself seen it is considered as, it is secondary evidence. C is the answer. And this is provided in section 63 of Evidence Act. Primary is in section 62 and 64. Next 65. The case of Ram Bharose versus State of UP is related with privileged communication. A is the answer, between husband and wife. Next 66. The case of Palvinder Kaur versus State of Punjab is related with confession. B is the answer. Next 67. Which of the following section is related with evidence as to affairs of state? Section 123. C is the answer. Next 68. Which of the following is correct statement? Leading question may not be asked in cross-examination. No, this is wrong. It is asked in cross-examination. It is mentioned in section 143. Questions intended to insult or annoy can be asked in cross-examination. No, this is also wrong. Leading question is defined in section 141. This is wrong. Leading question must not be asked in re-examination. This is correct. So D is the answer. Next 52. Opinion of handwriting expert under the law of evidence in India is relevant but not relevant. No. Relevant and is sole determinant. No. Relevant but not sole determinant of genuineness of document. C is the answer. It comes under expert opinion under section 45 Evidence Act. Next is 53. Under section 90 of Indian Evidence Act, presumption as to all document of 30-year-old, it should have been a document 30-year-old. The relevant date of computation of that document in the court is date of production of document in court या फिर Date of initiation of proceeding in which document is produced, no. Date of oral evidence by witness या फिर date of hearing. Date of production of that document in court in evidence. This should have been a proper statement. The date of initiating of proceeding in which document is produced. So let's say that proceeding initiated in January 2018. Now the document is given in 2020. So shall you compute that from here or from the starting of the proceeding? How does it matter? Whenever you give that document in evidence, the computation shall start from there. So A could be the answer, but this is also not properly mentioned, and this is also not proper. This is 54. Tape recorded a conversation is admissible in evidence if conversation is very important. No. Conversation can save the culprit. No. Conversation is relevant to the matter in issue, but the voice is unidentified. No. It must be relevant and voice shall also be identified. D is the answer. Next 55. The evidence relating to conspiracy is common motive of the conspirator and any act done in pursuance of it. या फिर common intention या फिर common of the conspirator and anything in writing in pursuance of it. Common intention of the conspirator and anything said or done written by any of them in furtherance of that intention. This is perfect. C is the answer. And where the provision relating to conspiracy, evidence relating to conspiracy, section 10, Evidence Act. Next 56, test identification parade is a corroborative evidence. B is the answer. It is not a substantive of evidence. And where in which provision you do test identification parade under section 9 Evidence Act. Next 57, the presumption under section 114A is a rebuttable presumption. A is the answer. What is 114A? Relating to presumption of consent in rape cases. Next 58, which section of Indian Evidence Act deals with the proof of customary practices? It is 35, 48, 49. D is the answer. Next 59, the court shall not take judicial notice of geographical divisions of world. It will take public festival notified official gazette, yes. National flag of foreign country recognized by government of India, yes. Official signature whose appointment is not notified in official gazette, no. D is the answer. And you can see section 57, 58 for that in Evidence Act. Next 60, the content of a document may be proved either by primary or by secondary. D is the answer. Where this is mentioned, it is mentioned in section 61 of Evidence Act. Next 61, A agrees in writing to sell a horse to B for rupees 1000 or 1500. So evidence cannot be given to show which price was to be paid for sale. This is correct. Can be given, no. Cannot be given, show the average of the sale price, no. Average, no. So A is the answer. And where this is mentioned, it is mentioned in section 93 of Evidence Act, and this is illustration A in that section. Next 62, public officer cannot be compelled to disclose communication made to him in official confidence if he does not consider that public interest would suffer by disclosure. This is wrong. Cannot be compelled to disclose communication made to him if he considers that public interest would suffer by that disclosure. B is the answer. And this is section 124 Evidence Act. Next 63, an accomplice is not a competent witness against an accused person. No, this is wrong. He is a competent witness against accused person and must be corroborated. In that case, he must be prosecuted. He is a competent witness. B is the answer. It is mentioned in section 133 of Evidence Act. It talks about accomplice. Next 64, examination in chief means examination of a witness by a party who calls him, not adverse party, not CGM, not superintendent, not chief SP. D is the answer. Examination in chief cross-examination and re-examination. There are three types of examinations mentioned in section 137 Evidence Act. 965. A judge in India is not empowered to put question of his own. No, he is empowered to put question on his own to the witness or parties according to his sweet will, or on his own to the parties in order to discover or obtain proper proof of the relevant fact. This is perfect. C is the answer. To Indian common law doctrines, no. C is the answer. And section 165 Evidence Act. So friends, here we have discussed all the questions of Evidence Act which came in the exam paper of Jharkhand Judicial Services from the year 2008 to 2018. अगर आपको इसमें कोई कमी लगी हो, कोई सजेशन हो, कोई एडवाइस हो, कोई कमेंट्स हो, तो आप जो है कमेंट सेक्शन में जाकर भी लिख सकते हैं. वी ऑलवेज अप्रिशिएट योर कमेंट्स. एंड अगर आपको ये वीडियो अच्छी लगी और एफर्ट्स हमारे अच्छे लगे हो तो उसको जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ, सो दैट दे कैन कम टू नो अबाउट आवर चैनल एंड वो भी बेनिफिट ले सकें. एंड अगर आपको हमारे एफर्ट्स अच्छे लगे हो तो इन एडिशन टू लाइक एंड सब्सक्राइब काइंडली गिव अस अ सुपर थैंक्स. सुपर थैंक्स इज अ वे टू अप्रिशिएट द कंटेंट क्रिएटर. आप जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए कोई भी अमाउंट जो है डोनेट कर सकते हैं. तो काइंडली गिव अस अ सुपर थैंक्स. सो फ्रेंड्स, थैंक्स वेरी मच फॉर वॉचिंग दिस वीडियो. थैंक यू.